I will remind people, like, this is really the first time the SEC has lost, but it's also the first time the SEC couldn't just bully the victim. They were stealing people's lunch money, and we had the fortitude, we had the courage, and willingness to really invest the money to fight. And I think it's incredibly important to the industry. And now there is a little bit of a blueprint that others can use. If they were to choose to appeal, that is going to take a very long time. The law of the land as of yesterday is crystal clear. XRP is not a security.
Welcome to the DeFi Standard, and this is Mickey B. Fresh. And after 933 days of a court battle, we celebrate a monumental victory in the cryptocurrency world. After Ripple, its triumph landmark victory in the legal battle that lasted 933 days has emerged in its clash with the SEC. This victory marks a significant milestone, not just for Ripple, but for the entire cryptocurrency community, but specifically for the XRP community, because this victory, in an electrifying summary judgment ruling, Judge Torres declared, and I quote, XRP as a digital token is not a contract, transaction, or scheme that embodies the Howey requirements of an investment contract. She says the digital token is not a contract or transaction. So I'm kind of curious why I still see on Twitter that, oh, well, is she going to acknowledge that secondary sales? I mean, this pretty much speaks for itself, that the digital token is not a contract. And we know there's been no case where the oranges are security. So this verdict effectively exonerates XRP the token from any allegations of being an unregistered security. The resounding echo from the courtroom was clear. The law of the land is XRP is not an unregistered security. And Ripple CEO Brad Garlinghouse was understandably thrilled with the outcome.
The SEC clearly lost as a matter of law, and the judge wrote, XRP is not a security, as a kind of intrinsic thing. In certain circumstances, which is kind of a narrow definition around institutional sales, it could be a security. This is a win for Ripple. It's also a win for the entire crypto industry, and I think that's why you saw the crypto industry react so positively.
After years of battling in court, Ripple has finally achieved what it has set out to do, to prove that XRP is not an unregistered security. So now, after this, I would say it's close to 5-year legal battle, is finally coming to an end. And some of you might be wondering, well, what about an appeal? John Deaton was on Real Vision, and he spoke about this appeal, and he explained that any appeal to the Second Circuit Court by the SEC to overturn Judge Torres' ruling would have to wait. The remaining portion of the case, which accuses Brad Garlinghouse and Chris Larson of aiding and abetting Ripple's institutional sales of XRP, must go through a jury trial first, which could take years, and then the SEC could appeal.
What your view is the likely outcome of an appeal, if one is filed, would be?
Okay. Well, here's the thing to know, that the judge, this decision, as we know, was a split decision, meaning that Ripple was found responsible for these institutional sales. But there were 2 executives who were also sued, and the SEC was charging them with aiding and abetting Ripple, the company, in violating Section 5 of the 1934 Security Act. And so the judge found that it's up for a jury to decide whether Brad Garlinghouse and Chris Larson were reckless in aiding and abetting, or whether they're not reckless. That's for the jury to decide. Regarding institutional sales, their individual sales on exchanges has been found in favor of them. The judge ruled, just like when Ripple sold on exchanges, not a security. So that jury trial has to take place first. The SEC or Ripple, they don't have an immediate right to appeal this case. Now, one of them or both of them could go to the judge and say, we're asking you, judge, for an interlocutory appeal. We don't want to do that jury trial. Will you certify that we can go up to the Second Circuit? And then the Second Circuit would have to agree to hear it. So it would require the judge to say, yes, I'll allow it, and B, the Second Circuit to accept it. So unless that happens, which I don't think it will happen, then we have to get that jury verdict first and then an appeal. And that jury verdict isn't going to take place in the next 6 months. So you're talking about a jury trial sometime next year and a decision sometime next year, and then the appellate process. So the thing to know is that this judge's decision, unless there's an interlocutory appeal, is going to be the law of the land in this case for the next 2 to 3 years, because it's going to take that much time before it gets to the Second Circuit.
That's extremely interesting, John.
So, the more they appeal, the higher it goes. The more, assuming we continue to win, the more it becomes, the implications are more substantial. They're already pretty substantial. But the other thing I would say is, look, if they were to choose to appeal, that is going to take a very long time. The law of the land as of yesterday is crystal clear. XRP is not a security.
So if you think of this situation now, if I'm Ripple, I'm going to jury trial, which doesn't matter to them. And you're not going to give the SEC a window of opportunity to appeal. I mean, there is a risk in them appealing, because if they lose, it could only cement it more. He did say, though, if Ripple and the SEC both agreed that they want a decision from the Second Circuit Court, then the judge could approve that. That's doubtful, he said, and I agree. It's very unlikely. Most likely, it's going to stay law of the land until we see legislation. And by the time years go by the jury trial, Gensler will be out of there. There could be a new administration, a whole new SEC. So you keep things as status quo, just like what the SEC did with Ripple. I would do the same thing if I'm Ripple. So I wouldn't expect any settlement or anything like that, because they have to prove those transactions, every single one of them, institutional sales, were done in the U.S., and they have to prove where they were done, how much were they for, the contract and everything. And she didn't go near that. Now, we don't know the details of that. I've not seen an answer. Now, those weren't done on exchanges. I mean, they have nothing to do with XRP, the token. It's just how they were done. And some people are asking, well, how does this affect Ripple and their institutional and ODL? Remember, this is only in the U.S. That's the courts only have jurisdiction over the United States activities. Things that happen in the rest of the world, they don't have jurisdiction over, and it's very clear.
Is a lot of the public discourse is around the question of whether XRP is a security or not. There are other issues here that I think are intellectually maybe even more intriguing and may even be more outcome determinative. Let me give you an example. There's a Supreme Court opinion called Morrison, and it basically says that the federal securities laws are designed to apply to transactions that occur in the United States. And there's a strong judicial presumption against the extraterritorial application of US law. And the lower courts have a variety of different doctrines to try to figure out when a transaction actually occurs in the United States. So one rule of thumb is, well, does the transaction close in the United States? Well, here's what's interesting. If you wind up transacting in XRP on a foreign exchange, that's not in the United States. So to the extent that XRP transactions are occurring elsewhere, right, in a foreign exchange, whether it's a security or not doesn't make a difference. The SEC can't reach it.
Right.
Now, more intriguing. What does it mean to confirm a transaction on a blockchain the way XRP is structured, which is a consensus mechanism, and it's an 80% consensus mechanism? Well, what does that mean? Suppose the node that gets you across 80% is located in Iceland. Well, does that transaction occur in the United States? Suppose that all of the nodes, right, that confirm the transaction are outside the United States. Suppose that, 50% of the node. I mean, we don't know. And then here's a separate question. And here, I just don't know how the coding and is it possible to look at the history of that blockchain and try to figure out where it was confirmed, who confirmed it, and who the confirming nodes were? I have to go back and look at that. The burden of proof is on the plaintiff. And if you can't determine where this happened, how do you establish where the transaction actually closed? So it may be that even if you decide that this is a security, and that's going to be hotly litigated, the SEC may not be able to reach transactions unless it can prove that they occurred in the United States. And given the architecture of the system, it may not be able to do that.
Right.
So by the way, so if that's right, the SEC in a certain sense can win the battle and lose the war.
Yeah, we'll continue to invest heavily. There's things we haven't been able to do that now we have clarity. And again, if you go back years, I've been the words, I want a level playing field and I want clarity for the XRP community and really for crypto overall. We really have that now. And that's profound. I don't know if it's an irony or how exactly to describe it, but the fact that now that there are really only two digital assets that are cleared in the United States, officially cleared, Bitcoin and XRP. Now, I don't view that as a good thing. I just view that as a statement of reality of where we are right now. And I think it does call upon elected officials to, lean in and make sure that dynamic, that because they sued us and we got clarity and they've given clarity to Bitcoin, they won't even now confirm after having said it previously about ETH. So look, I think it puts XRP in a really unique position that and it lets Ripple do things we couldn't do before.
So Ripple's lends XRP to most entities anyway. And we're going to start to see a winding down of this centralized entity just doing as they please with the XRP. And we're going to start to see more of this programmable distribution and economic incentive model take form. So be aware of that. And I have the utmost respect for John Deaton and Jeremy Hogan and everything they've done, especially Deaton. But at the same time, we have to keep in mind that, there's a legal side of looking at things, and then there's like the fundamental crypto side here. Every single network, for the most part, distributes things programmatically. There's not like one entity there that's selling to institutions. And no, XRP is not special. It's just like any other crypto. So that's most likely going to be distributed in some way that will be programmable. We don't know. We'll see. But there's no dependency on selling XRP at all for Ripple. And even what wallets send right now, it draws it from a pool. When the XRP comes out of escrow, it goes into a multi-sig. And then there's crypto conditions, which is another condition-based system. We don't know what that does. Nobody knows. No attorney knows. Nobody knows. And what decides where it goes and who's it go to. That's their proprietary thing. But right now, it all goes to them. Now, years back, it looked like there was a markets committee that decided where it went. But that's over. Been over. And actually, what's ironic in this whole thing is the programmatic sales is what bothered most of the community because they thought it was putting downward pressure. Probably never really was. And that's actually the thing that brought the clarity. I mean, I do find that kind of ironic. Nobody really predicted that. I mean, the institutional sales were kind of like direct. And if you do look on, Masari had a graph. Everyone always assumes like from way back in the beginning, there were no sales way back in the beginning because there was no market for XRP really. You couldn't sell in 2014, 2015, 2013. It only started in 2017 really. Before that was like under 5 million. So that's when most of these institutional sales kicked in, and it was mostly to market makers. Now, we'll have to watch and see how the jury trial plays out, but if those were done in the U.S. jurisdiction or not, she didn't really say in the ruling. She didn't even go near it. So there's no appeal that could happen right now. As of right now, it's going to jury trial for just the aiding and abetting. And in that, they're going to discuss the institutional sales. So XRP, that's what I think is more important right now. So this legal clarification is expected to faster exponential growth in the XRP ecosystem and Ripple's institutional partners, as well as a new wave of open source projects, are now poised to build decentralized applications on the XRP native network and its sidechains. With the upcoming launch of the automated market makers on the XRP Ledger, we can expect an exciting surge of innovation and development. This victory is not just about one company or one digital token. It's a win for the broader cryptocurrency community, setting precedent that will undoubtedly influence future regulatory discussions, and it's a blueprint for other, Coinbase, for example, that's fighting now the SEC, a blueprint for them to go to court and then deal another blow to the SEC and Gary Gensler. The message is clear. The future of crypto is here, and it's brighter than ever. Let's look forward to the exciting developments ahead, and explicitly for XRP, because the law of the land is only 2 assets. So now anytime you see like these institutional apps like Fidelity, a Robinhood, we should see always like Bitcoin, XRP should always be in that mix because it has that explicit legal clarity. I mean, it says it in the document, in the filing, like pretty black and white. I mean, it doesn't get any clearer than that. I don't know what some people were expecting, but it's pretty clear. It says the digital token is not an investment contract. I mean, we saw the listings, right? And here's one that I think was really telling was I'm in New York, and Gemini was one exchange that we could use here, and that they never offered XRP, and they were very quick to offer XRP as soon as this ruling came out. So it goes to show that there is definitely a regulatory aspect of like why they didn't offer and list XRP. But one thing we have to keep in mind, less and less focus on these centralized exchanges. The DEX on the XRP ledger throughout this whole case, it was working fine. The whole ledger, nothing. There was no limited use. Secondary exchanges will be less and less important every month that goes by. And ultimately, the goal is to where they tap into the on-ledger activity. Why is Coinbase building Base? Why are they working with all institutional infrastructure? Because the infrastructure for the whole crypto market is changing. The trading market, the blockchain markets, and tokenized assets aren't going to trade on legacy order books. So in the next video, you're going to see the guy from BlackRock, executive, say that AMMs and liquidity pools are absolutely fine. That's a fig leaf that everything has to trade on order books and centralized exchanges. It's just we need to know who's in the pool. Just how everyone knows they're trading on Coinbase, everyone's KYC'd. It's going to be the same way with liquidity pools. It's just a different way of trading and providing liquidity. I don't think one's better than the other. I think that together they work the best out of all than anything.
and Joseph Shalom, BlackRock Head of Strategic Partnerships.
Institutional DeFi, but there will be a role for smart contracts, for deep pools of liquidity who can basically create really creative pairs and allow transactions in a different way than can happen in the centralized space. People talk a lot about, oh, DeFi won't work because it's automated market making and we need central order limit books. Like, that is just a fig leaf. We need clear understanding of who is in a pool.
So that's the situation we're in now. And Brad Garlinghouse has said that this is going to allow for the ecosystem to incentivize XRP ecosystem with XRP. So that was ruled cleared. That is not an unregistered security. She explicitly said that. And I think that's important for the ecosystem and the community that it got that clarity. And that clarity for paying employees as well was important, and also for the programmatic sales. Not like those are going to happen again, but it frees all the exchanges. That's what everyone could offer XRP. Like, the token itself it is cleared. So this is the law of the land. And for the most part, it's just solidifying what everyone already knew. It's just Ripple had to take this all the way to the summary judgment. This is why there was no settlement. I kept saying no chance this is going to settle, because they're never, even if the SEC came out and acknowledged XRP is not a security, this is far more powerful, and it's by law that it's not a security. No matter what the SEC would have said in the settlement, wouldn't have mattered, because it's not law. Those speeches, whatever Gensler says, means nothing. What the court says, as Grunfest said, these decisions will be made by the courts. Even Gensler said that. So now the courts have decided, and she kept it very strictly to Howey. And we're ultimately going to get legislation that's going to provide even more clarity. But for the time being, this is the law of the land. And the U.S. is just one jurisdiction. I know probably many of you listening are from the U.S., and sometimes we get stuck in this bubble. But whatever Ripple does in other countries doesn't matter to the U.S. The XRP Ledger is not in the U.S. It's not U.S. based. Like, the XRP Ledger doesn't live in the U.S. jurisdiction. It's a global. Ripple's base operations have headquarters is in the U.S. They have plenty of other subsidiaries outside of the U.S. that could sell XRP to any institution. Doesn't matter. That's not in the U.S.'s jurisdiction. So there's really not that much hampering here that people make it seem, because everyone puts too much weight in that when the U.S. makes law, that it's all of a sudden, well, not makes a law, but rules that it's the world's decision. And it's not. And I think that's sometimes unclear. And this is good for all tokens. So if you hold any other tokens, so this is a win on all fronts, and we should be very excited. I think price-wise, I'm not going to go there, but I'm working on a valuation framework, which will give you a much better idea of what to expect. And speculation is not going to be what does it. It's going to be storage demand and utility that drives that. That will ultimately be what you're looking for. If you're here for a quick pump, well, you're probably going to keep getting disappointed. I'm Mickey B. Fresh, and I'm out.
If they were to choose to appeal, that is going to take a very long time. The law of the land as of yesterday is crystal clear. XRP is not a security. And, you're obviously seeing the U.S. exchanges, Gemini, Bitstamp, Coinbase, everybody now has, I don't know if everybody has already, but they've announced their intention to, I believe. So I think that the SEC may choose to do that. Hard to predict. I think there's risk if they do, but even if they do, that is going to take years. And for the years during that time, it's the law of the land is XRP is not a security.